Hello everyone. So in this session, let's discuss about the MTP Amendment. So this is a very important topic as the MTP Act has evolved over the years. With the initial MTP Act, which was passed in 1971, there has been some very significant changes that happened over the years, and the last MTP Amendment was in 2021. So many changes have come over the years, especially to ensure that safe abortion practices are being practiced, and again complications related to abortions come down. Again, in this you will see that there are significant changes, especially related to the period of gestation till which MTP can be done, who can undergo MTP, special categories of women, who can do the MTP as such. Again, there has been changes, the confidentiality of women. We are going to see them in detail in this session. Yes, this is a very important topic as such, especially as a healthcare provider. We have to know these changes so that we practice within the legal framework. At the same time, we respect the rights and autonomy of the pregnant women as well. Yes, so let's move into this topic. So what is MTP? As you all know, MTP is basically the procedure to terminate the pregnancy. Either it can be done using medical methods, or it can be done via surgical methods, medical or surgical methods. This is the timeline of the abortion legislation in India. Initially, the MTP Act was passed in 1971, which again had few changes in 2022, 2023. Finally, the amendment came in 2021, and we are going to discuss about this, the key changes in detail in this session. Yes, this is the focus of our discussion today. So as I discussed, the MTP Act was passed in 1971. What about before that? Before that, MTP was not legal in India. Performing a voluntary termination of pregnancy before 1971 was considered as a criminal offense. Again, it was much difficult for the women as such to go ahead with safe abortion practices, any form of abortion practices prior to 1971. And in India, 1% of maternal death are actually related to abortion. 1% of maternal death per year is attributed to abortion. Again, these are various causes apart from the bleeding, apart from obstructed labor, infections, hypertension, which are very important, significant other causes. Again, abortion also constitutes nearly 1% of maternal death per year. If you take all the pregnancies, nearly half of the pregnancies are unintended. It is found that 6 out of 10 pregnancies are actually unintended, and among this 6 out of 10 asses, 3 out of 10 pregnancies are actually ending up in abortion. 3 out of 10, approximately 33%. So it is very important that these women get a safe abortion practice so that they don't land up in some severe tragic complications. There are all these septic abortions, injury to uterus, perforation, which can happen, especially if this is performed by someone who is untrained in a center which is not equipped with facilities for MTP. So again, it's important we give that proper safe measures to these women. It is their right, so that they get that safe methods. Repeating that once again. So it is very important that we provide the safe care for these women so that they don't land up in the wrong hands. So unsafe abortion in India leads to mortality, morbidity, and again hampers the women's full participation. 8 out of 10 maternal deaths per year are due to abortion, and is the third leading cause of maternal mortality rate. And nearly 2 out of 3 abortions are performed via unsafe practices. And nearly half of the pregnancy-related deaths are seen in women and girls under 24 years of age. So this is the need for MTP Act. The legal restriction and other barriers let many women find it difficult or impossible to access good quality abortion care, and they may induce abortion themselves either using unsafe methods or seek abortion from unskilled providers. Thus, the legal status has dramatically affected her access to safe abortion. Again, what is meant by legal abortion? Abortion can be termed legal only when the following conditions are met. It should be performed by someone who is legally eligible to perform it. That is, by a medical practitioner who is registered under the Act. It should be done in a place which is again approved by the Act. Again, the condition for performing MTP and the gestational age for performing MTP has to be fulfilled. Other requirements of rules and regulations are combined with as well. Now, regarding the grounds for performing MTP, this is also the indications for performing MTP. It can be broadly divided into four. That is therapeutic, eugenic, social and humanitarian indications. Among this, let's discuss about them one by one. First is the therapeutic indication. Therapeutic basically is related to the pregnant woman. Any condition where there is risk of life of the woman, any condition that can actually be detrimental to her health condition and there is a risk to the life of the woman, or there is grave injury to either the physical health or even mental health. Let me give you some examples related to this. Whenever you are doing these procedures to save the life of the woman, such as she has severe cardiac disease, NYHA 3 or 4 with history of decompensation in previous pregnancies, chronic glomerulonephritis, malignant hypertension, intractable hyperemesis, cervical breast malignancies, diabetes mellitus with retinopathy, all these are the various therapeutic indications. Next comes eugenic indication. Eugenic, remember, it is related to the fetus. So, any form of risk of physical or even mental abnormalities are there in the fetus, which can further on lead to handicap for the fetus. These are included in the eugenic causes. Let's have a look at the various eugenic causes that you should know. Any form of structural problems in the fetus, such as anencephaly, neural tube defects are there. Any form of chromosomal problems, such as Down syndrome, Klinefelter syndrome, Turner syndrome. Any form of genetic problems, such as hemophilia, thalassemia, all these abnormalities constitute indication for MTP as per eugenic indications. Fetus likely to be deformed due to action of teratogenic drugs. Maybe there was teratogenic exposure to drugs such as warfarin, phenytoin or valproate, any form of teratogenic drug, or even radiation exposure in the early pregnancy where embryogenesis is happening. Infections such as rubella, viral infection, especially in the first trimester. These are the various eugenic causes. Next, we have humanitarian cause. What is meant by humanitarian cause? Causes especially pregnancy which is especially caused by rape, which is presumed as a grave injury to the mental health of the girl. So again, rape comes under humanitarian cause. Finally, we have social cause. Under social cause comes contraceptive failure. This is one of the most common causes as such for which MTP is done. This is often the most common cause which is misused by the public as well. Many a times they give this history of contraception failure, which becomes a solid ground for performing medical termination of pregnancy. Please note, in India, the sex selection is not an indication for pregnancy termination. Sex determination is illegal in India. Even if sex determination is done, it is never an indication as such for performing an MTP. Now, let's go into the salient changes that happen in the MTP Amendment Act. There are so many changes. Let's go into it one by one. Side by side, we are going to compare it with the previous MTP Act as well, so that you are aware of the changes and the significant key change that happened from the previous one. So, previous Act, we used to do MTP till 20 weeks. Till the period of gestation of 12 weeks, opinion of one registered medical practitioner was required. From 12 to 20 weeks, there was requirement of 2 registered medical practitioners. Now, till 20 weeks, there is only requirement of 1 registered medical practitioner, and 20 to 24 weeks, 2 registered medical practitioners are required. So, till 20 weeks, 1 registered medical practitioner. 20 to 24 weeks, there is requirement of 2 registered medical practitioner. What is the main outcome due to this? There is a potential increased number of facilities, especially in the public sector, for providing this safe provision of MTP till 20 weeks. There is also a modification regarding the vulnerable group of women. Previously, MTP was allowed only till 20 weeks, especially immediately only if that is to save the life of the pregnant woman. Now, 2021 amendment states that the special category is extended from 20 to 24 weeks. And even beyond 24 weeks also, we can go ahead with MTP if there are substantial fetal anomalies in the fetus, Again, after approval from medical board. So beyond 24 weeks, after approval from medical board, if there are substantial fetal anomalies, that is birth defects not compatible with the life, yes, medical board approval is required. So in this, they have increased access for these vulnerable women to safe and legal abortion services defined by the committee, the rules of the committee, that is violence victim, minors. So many special category are there. We are going to see them one by one as well. Again, they have modified the limit of termination. Previously, termination was only possible till 20 weeks, and many times we were in such a hurry to perform the anomaly scan. Like for example, we always used to do this anomaly scan prior to 20 weeks itself. If at all the 20-week cutoff was just passed, many times they don't get the anomaly clearly in 19-week scan. They just ask to repeat the scan. Once 20 weeks was passed, it was slightly more difficult to perform the MTP. 20 was the upper limit of cutoff. Now, upper gestational limit does not apply in case of substantial fetal anomaly after approval from medical board. So, the main outcome here is it has increased access to safe and legal abortion, especially for termination with substantial fetal anomaly, thus reducing unsafe abortion. Even court cases are reduced due to this. Next, there is a small modification regarding the contraception failure. So initially the condition, that is failure of contraception, which was our social causes, was only for married woman or her husband. Now they have removed the word married as such. Married woman, husband, all these terms are removed for any woman or her partner. The person need not be married as such. Any woman or partner, they have a contraceptive failure, it again forms a solid reason or solid indication for proceeding ahead with MTP. So it has increased safe and access of safe and legal abortion to any woman irrespective of marriage status. The person need not be married also. Even then you cannot deny abortion. Even married, unmarried, doesn't matter. If there is history of contraception failure, we have to proceed with MTP. Especially with the upcoming change in legal age of marriage, this is important. The advancement of increased access to safe abortion. Okay, the next is about the confidentiality of the woman. So there is an insertion of a new clause which strengthens the privacy and the confidentiality of the woman. The name and other particulars of the women who are going to terminate this should not be revealed to any person. Confidentiality has to be maintained except to a person authorized by law for the time being in force. Except for someone who's authorized by law, you should never ever disclose the details. Even in the MTP file, we don't write the name of the person or the age of the person. We just write the MTP number as such. Maintaining the confidentiality is very, very important. This ensures that there is increased privacy, confidentiality. It safeguards the right and dignity of the woman, provides respectful bias, free services including counseling and contraception as well. So again, this is just a summary table dividing all these key changes. Previously married, unmarried was given. Now married, unmarried, they are just mentioning the women as such. There is a change in mindset of the law, especially in contraceptive failure. As we discussed about the gestational age cutoff till 20 weeks, one registered medical practitioner, 20 to 24 weeks, there is requirement of 2 registered medical practitioner. Upper limit of termination now is till 24 weeks. Even beyond 24 weeks, MTP can be performed after approval from medical board. In case of contraceptive failure, upper limit for termination is only 20 weeks. Generally, it is 24. Especially, we have a special category that is between 20 to 24 weeks. Contraception failure is still 20 weeks. If there is substantial fetal anomaly, even beyond 24 weeks is possible. Breach of confidentiality should not happen. Confidentiality is very important, and if there is some breach of confidentiality, there is a fine of 1,000 and imprisonment of 1 year or both. Now, when pregnancies can be actually terminated by a registered medical practitioner, what are the key indications? So, MTP Amendment Act 2022 prioritizes the confidentiality and safety of the woman. The details of the woman, including her name, age, everything is kept confidential. It is very important that we maintain the confidentiality. Even in the MTP register as well, we don't write the patient's name and details. We have an MTP number, which is just put in the front of the file as well as within the case sheet. You should never disclose the name or details related to the patient, and if that is done, it is again punishable by law. The failure of contraceptive has been extended to women and her partner. She need not be even married, it need not be a husband, yes, just to the woman and partner. It is more inclusive as such. So under rules of the MTP Amendment 2021, it defines special and vulnerable category of women, and which soon discussing who are these special category in whom you can do MTP till 20 to 24 weeks. The norms of registered medical practitioners whose opinion is required for medical termination of pregnancy at each period of gestation has been given as well. We are going to go into the details of that soon. The power and functionals of the medical board formed by each state has been given in detail. Yes, let's go into these detail in a short while. So these are the special category or the vulnerable category of women. This include any survivor of sexual assault or even rape or incest. Women who has a pregnancy in humanitarian setting, disaster, emergency situation as declared by the government. Any change of ongoing marital status. For example, she has been recently divorced, or maybe she has been widowed. All these are again indications in which you can go for MTP between 20 to 24 weeks. Women with physical disabilities, major disabilities as per criteria under Disability Act, or mentally ill women including mental retardation, minors, or fetal malformation. That is, there is substantial risk of being incompatible with life, or if the child is born with it, there can be significant physical or mental abnormalities to cause serious handicaps. All these are taken as the special category or vulnerable category where MTP is performed between 20 to 24 weeks. Please note, women who come with contraception failure, the upper limit of termination is 20 weeks. So let's summarize the key differences that happened between 1971 till 2021. Now here there is a change of mindset as such. Married woman and her husband, that terminologies has been removed. Both married as well as unmarried women and her partner can approach for MTP. The legal limit of termination of pregnancy was 20 weeks previously. Now it is extended till 24 weeks in special category of women, as well as even beyond 24 weeks MTP is possible after approval from medical board. Opinion of one medical registered practitioner was required till 12 weeks as per the previous act, and 2 till 20 weeks. Now it is one registered medical practitioner till 20 weeks and opinion of 2 registered medical practitioner till 24 weeks. Substantial fetal anomaly. Even if anomalies was there, previously upper limit of cutoff was 20 weeks. Now till 20 to 24 we can go ahead, and even beyond 24 MTP is possible if there are substantial fetal anomaly after approval from a medical board. So the confidentiality of the woman has to be maintained, and if there is a breach of confidentiality of the woman in the sense that either name or details have been revealed, there is a fine of up to 1,000 rupees and an imprisonment of nearly 1 year or even both. Yes, so it gives a lot of emphasis for even maintaining the confidentiality as well. These are the salient sections of the MTP amendment, which is divided from 1 to 8. One is the short title, extent and commencement. I will be telling you what are the key salient features included under each of this. 2 is related to the definitions. 3 is related to when can it be terminated by the registered medical practitioner. 4 is related to place where the MTP can be done. 5 is some exceptions where section 3 and 4 does not apply. 5A is for protection of privacy, that is confidentiality of the woman. 6 is power to make rules. 7 is power to make regulations. 8 is protection of action taken in good faith. Yes. Let's see the key salient features that you have to note for each of this. So short title, extent and commencement. This act may be called the Medical Termination of Pregnancy Amendment Act 2021. It extends to whole of India except the state of Jammu and Kashmir. 3. It shall come into force on such date as the Central Gazette may by notification in the official Gazette. Section 2 is all about the various definitions regarding guardian, medical board, medically ill person, minor, registered medical practitioner, even termination of pregnancy. Section 3 addresses when the pregnancy may be terminated by the RMP. One registered medical practitioner till 20 weeks, two till 20 to 24 weeks. You might be absolutely thorough with this information till now. As we discussed, these are the special scenarios in which the MTP can be done till 20 to 24 weeks. We already saw the special category or the vulnerable category of women. Beyond 24 weeks, as we discussed, MTP can be done if there are substantial fetal anomaly after approval from the medical board. So, who constitute this medical board? What are the function and role of a medical board as such? Medical board is mainly constituted by 3 doctors. They are, remember, anyone who is related to the fetus as such, a gynecologist, pediatrician and radiologist. These are the 3 main doctors who constitute the medical board. So, the powers of medical board include it can allow or deny the termination of pregnancy beyond 24 weeks. So, after 24 weeks, once you give an appeal for termination, they are going to thoroughly assess the case, whether the anomalies are sufficient enough to cause substantial fetal problems or long-term handicap in the fetus. And after this, either it can be rejected or accepted as well. The medical board can even co-opt with other specialities and ask for additional investigation if required before deciding for the termination of pregnancy. So these are the functions of medical board: to examine the woman and her reports who may approach for MTP, provide opinion of the medical board. Medical board opinion is given in Form D. I will teach you soon the various forms that are often associated with MTP. We have different forms: A, B, C, D, Form 1, 2, 3, all those 6. We will see in a short while. So, it will provide the opinion related to the termination in the Form D. Either it can accept or even reject. And this has to be given within 3 days of receiving the request for medical termination. So, this has to be provided within 3 days. Not only giving this acceptance of rejection, it will even ensure that the termination procedure is carried out smoothly. It ensures that the further advices are given to take out this procedure safely, and this has to be done within 5 days of receipt of requests for medical termination. So initially opinion was given within 3 days, and all this procedure, all this are safely carried out within 5 days. All these things are ensured by the medical board. So the RMPs who can perform the MTP, again there are criteria for these registered medical practitioners. The criteria include any registered medical practitioner registered immediately before commencement of Act with minimum of 3 years of experience, or any registered medical practitioner with 6 months of house job in Obs and Gyn and has 1 year of experience in OBG in any hospital, or registered medical practitioner who has assisted 25 cases of MTP, and among this at least 5 cases has to be done independently by the person. Any registered medical practitioner who has 3 months of experience in Obs and Gyn and 10 cases of MTP independently. Any degree, that is diploma, PG, either MD, MS or DNB in Obs and Gyn. Yes, these are given under MTP rules. Please note that all of these personals that I described here, they cannot perform in all period of gestation. It slightly differs. For example, the one that we discussed here, person who has 3 months of experience or 10 cases of independent MTP, that is medical method of abortion, they are allowed to do MTP only till 9 weeks. This scenario, registered medical practitioner with 25 cases and 5 cases independently, they can do MTP till 12 weeks. Rest are same, like the one as we discussed, 6 months of house job, 1 year of experience, PG, diploma, they can do even beyond that as well. Especially when you are doing MTP less than 20 weeks, only one among these persons are required. Beyond 20 weeks, 2 registered medical practitioners are required. Yes, for clarity again, this are saying like for each period of gestation, how it is given over here. Rather than that, let me give you period of gestation wise as well, so that it is completely clear for you. So as we discussed, till 9 weeks, either it can be a person with 3 months of experience or 10 cases of MTP, or a person who has 25 cases of MTP and 5 done independently. Any degree, either diploma or post-graduation in Obs and Gyn, or 6 months of house urgency in Obs and Gyn. Yes, all those category, everyone that we discussed can perform till 9 weeks. What is the difference that you see till 12 weeks? You will see that this category has been removed. That is 3 months of experience and 10 cases of MTP. That's only till 9 weeks. Rest is same. Anyone registered medical practitioner, rest is same. Again, you will note that this subcategory, that is person who has assisted in 25 cases and 5 done independently, that is only till 12 weeks. You will note that from 12 to 20 weeks that has been removed from the criteria. Yes, rest are same. Now, considering beyond 20 weeks, what is the key difference? Till now, only one registered medical practitioner was required. Now, 2 registered medical practitioners are required. Yes, have a note of this regarding who can do the MTP. So next we have section 4, which describes the place where the termination can be done. So either it can be a hospital which is established by the government, or place which has been approved by the government or district level committee. So there are some specifications regarding termination. Less than 12 weeks and more than 12 weeks, that is slightly different where you can actually terminate. When you are going ahead with a termination less than 12 weeks, that center should have a gynecology examination or a labor table, sterilization equipments, drugs and parenteral fluids, facilities for treatment of shock, and facility for transportation. Whereas when the termination is done beyond 12 weeks, there are some additional requirements. Operation table has to be there, instruments for performing abdominal and gynecological surgery. If at all she lands up in surgery or maybe hysterectomy, all that necessary things has to be available, including the OT table, the instrument, the facilities for performing abdominal and gynecological surgery. Sterilization equipments, drugs and parenteral fluids are same, and anesthetic equipment and resuscitation equipments are also required when doing an MTP beyond 12 weeks. So as we discussed here, a place which is approved by government or district level committee. What is meant by this district level committee, or who constitute this DLC? So DLC is a regulatory body. It is constituted by minimum of 3 members, maximum of 5 members, including the chairperson. That is the Chief Medical Health Officer. So the main composition of this DLC includes 1 medical person. Either it can be a gynecologist, surgeon, or even an anesthesiologist. 1 person from the local medical profession, either an NGO, Panchayati Raj, or institution of the district. At least 1 member has to be a woman. So minimum of 3 members, maximum of 5 members are included in this DLC. The tenure is maximum of 2 calendar years. The NGO members shall not remain in the committee more than 2 terms or 2 years. So next, let's move ahead with section 5. Section 5 is an exception to what we discussed in section 3 and 4. There are some special scenarios where you can actually bypass the section 3 and 4 only in very special scenarios. Before going to section 5, let me quickly tell you what was section 3 and 4. Section 3, we saw who can do the MTP as such till 20 weeks, 1 registered medical practitioner, 20 to 24, 2 registered medical practitioners were there. And in 4, we saw the place where you can do the MTP. So what section 5 states is that you can actually bypass this section 4 and even section 3B, that is telling 2 registered medical practitioners are required between 20 to 24. You can bypass this if MTP is done in good faith, so as to save the life of the pregnant woman. If you are doing medical termination of pregnancy in good faith, where termination is necessary to save the life of pregnant woman, you can even do the MTP with 1 registered medical practitioner. You can even do the MTP in a place which is not registered for doing an MTP as well. This is not done every case. This is only done for this exception where MTP has to be done to save the life of the woman. So this subsection 3(2) is basically telling that 2 medical practitioners were required between 20 to 24 weeks. Even 1, with 1 you can do if it is to save the life of the woman. Even you can do at a place which is not registered as well to save the life of the woman. But please note that when you are performing this MTP, it has to be done by a registered medical practitioner, not by someone who is not registered or maybe a quack. If anyone who is not registered is performing an MTP, it goes ahead to tell what punishment will be given. There will be rigorous imprisonment which shall not be less than 2 years but may extend up to 7 years. So definitely it has to be done by a registered medical practitioner itself. If not, it's a punishable offense with a minimum of 2-year imprisonment, maximum of 7 years of imprisonment. Section 6, 7, 8 tells about the power to make MTP, power to make regulation and protection of action taken in good faith. These are the various forms in MTP Act. We have form A, B, C, D, E and 1, 2 and 3. Let's have a look at these key forms. This is form A. Form A is related to the place of approval for MTP. Approval of a place for MTP. It has again the various details of it. Next, form B is the certificate of approval again for the place to do the MTP. Form C, remember C for C. C is the consent form. You will see often this attached when the MTP is being done, which has the basic details of the patient, the signature of the patient as well. If at all it's a minor or a person who is mentally ill, the guardian is going to sign it for them. Yes, again signature is only, the main signature is actually needed from the women. It is not required from the partner or the husband as such. When it is a minor, the main consent has to be given from the legal guardian. So as we discussed, no pregnancy of a woman who has not attained the age of 18 years shall be terminated without the consent of the guardian. In simple words, she has not attained 18 years or she is mentally ill, guardian consent is required, or else the pregnant woman's consent is required. This is form D. Remember, D is from the medical board. It is the report of the medical board. Yes, report of medical board. Again, you can see it is going to check all the findings in the patients. It is going to assess whether the MTP is required, whether it is causing a substantial fetal anomaly. Finally, it is marked as either allowed or rejected, that is denied. Again, the members who constitute the board has to sign it as well. So that is form D. Next, form E is for the opinion from 2 registered medical practitioners. If MTP is done from 20 to 24 weeks, this form has to be attached, which has to be signed by 2 registered medical practitioners. This is form 1 showing the opinion of registered medical practitioner mentioning the indication for MTP. So in this you have to state why the MTP is being done. In the next part of the form 1, you can see we have to take why it is being done. Is it humanitarian, social cause, eugenic cause, therapeutic? That causes are described in detail. You have to mention that. Form 2 is the monthly reporting form. This has to be sent to the district authorities for all medical as well as surgical MTPs that is being done. In this we mark at what duration this MTP has been done, what's the religion of the woman, whether she has accepted any form of sterilization technique, and the reason for performing MTP. This has to be sent to the district authorities every month. Form 3 is the admission register for case records. Again, in this the details have to be filled. So any woman comes for MTP, you have to proceed with confirming the pregnancy, confirming the gestational age, identify the need for MTP. Is there any indication for MTP? Discuss the various methods of MTP, both medical as well as surgical method. Even contraception counseling has to be given. She should not come back to you again and again for MTP. Proper contraception counseling has to be given for the patient. Then the informed consent is taken as we discussed. C for consent. Form C is for consent. You complete the form 1 as well. Then you proceed with performing the MTP. After that, the serial number should be written in a sealed envelope. Complete form 3, that is admission register for the patient. All forms has to be sent. Initially, it is kept in the custody of the owner of the hospital. Only the CMO can inspect these confidentiality forms, and strict confidentiality has to be maintained, and this is sent to the CMO every month. In case of medical abortion, all forms has to be filled. All records can be preserved for at least 5 years. Yes, all these records have to be kept for a duration of 5 years of last registry. In admission register, serial number will start from the month of January. So this is form 1 till 20 weeks. Monthly statement has to be sent to the CMO. We already discussed these things. Now a quick word about illegal abortion. The section 312 describes illegal abortion with consent of women. The punishment is, if fetus is not quick, punishment is for 3 years. If fetus is quick, the punishment is for 5 years with fine. Yes, 313 describes illegal abortion without the consent of women with a punishment of 10 years or lifetime imprisonment with fine. 314 is death of the woman during abortion. If abortion was done with consent, it is 10 years with fine. If abortion was done without consent, it is 10 years or lifetime with fine. Yes, this is about illegal abortion. So MTP amendment is something very important. This is something very practical as well. Yes, hope you understood all the key points that you have to gather from the main amendment that happened in 2021. Yes, that's all. Thank you.